Welcome. Welcome to this, the fourth debate in the series of 6 debates as part of this wonderful summer series. I'd also like to welcome the OSHER organizations at 5 different colleges who are getting this same performance live streamed to them. That is going to the University of Kentucky, University of Georgia, Granite State University, University of Massachusetts in Boston, and the University of Vermont. All of them have people in their own auditoriums who are watching this debate live. I want to reiterate, if you please turn off the cell phones in respect to the speakers. If you need to exit this during the performance, please use the back exits rather than the side. You've been given note cards, and again remind you, if you want to write down your questions and submit them to people here, hopefully, we get a lot of questions, but hopefully we'll be able to answer the ones that we find are the most relevant to the subject. DVDs, we've been getting a lot of requests. We make DVDs of all of these debates, and they're available. Actually, you can buy them after a debate in the back. This is the 1 week where the people are on vacation. So if you want a DVD, you have to do it after either of the next 2 events. And it's again, a record of the entire debate. I want to take the opportunity, of course, to thank our underwriters, the John and Dorothy Byrne Foundation, Libel Law, Estate Planning and Settlement, Dartmouth College, celebrating their 250th anniversary this year, Dartmouth Coach, and Kendall at Hanover, and the Ledyard Bank and Advisors. Also for this particular session, the Commonwealth Financial Network, with Pete Faley and Phil McCall. Now thank you. They sure make it possible. The debate today is freedom of the press. And I just want to remind you that the Bill of Rights and the First Amendment, in which they enshrine the freedom of press in the Constitution, was signed in 1791, when the only press were the written word, the press. But since then, we've proliferated to the media and digital media and TV and websites and so forth. So they're going to be looking at, in the debate, and your questions hopefully can address the entire scope of media, not just the written press itself. It's my pleasure to introduce the speakers. It's another wonderful group of accomplished scholars and practitioners. RonNell Andersen Jones got her BA from Utah State University, summa cum laude, GPA of 3.99. Got a master's at Oxford in 1998, and her law degree at Ohio State University Moritz College of Law, summa cum laude, first in her class of 202 students. She was president of the Ohio State University Women's Law Caucus and editor of the Journal of Communications Law and Policy. She was admitted to the bar in 2001 with the highest bar exam score in the state of Ohio that year. She clerked for Judge William Fletcher of the U.S. Court of Appeals 9th Circuit, and then went on to clerk for Justice Sandra Day O'Connor at the U.S. Supreme Court. Her relationship with Justice O'Connor was rather remarkable, because afterwards, Justice O'Connor asked if she, RonNell Andersen Jones, would join and co-teach a course at the University of Arizona, and they did it for 7 years together. Can you imagine a faculty like that teaching a course? She is currently professor of law at the University of Clark Law School and she's also assumed the role of Associate Dean of Academic Affairs. 3 times she's been voted the law school Professor of the Year. On a personal side, the genes run in the kids. She has a 15-year-old son and a 12-year-old daughter. 12-year-old daughter is right now in Chengdu, China, taking immersion courses in Mandarin. That's one speaker. The second speaker is Andy Phillips. Andy's a graduate of Indiana University and the Northwestern School of Law, where he, in 2009, graduated again, cum laude. He has worked for a major law firm, Kirkland Ellis, in the U.S., and now he has joined a wonderful young company that are really specializing in the kind of defamation law that we'll be covering today. What Andy does is litigate defamation lawsuits primarily. He represents many major corporations and individuals who have been defamed by reckless reporters or TV analysts or other media, and where the damage has been done and where that party is deemed guilty before being given the opportunity to be known to be innocent. So he goes after these hostile reporters intent on these false stories that can really affect the reputation of the individual or the company. And so he's made that into a major event. When he came here, after he got to the Hanover Inn, he walked across the bridge because someone told him he could get into Vermont by just simply walking down to the river. And he's here because he has a new child in the family who's only 10 weeks old, and he said he could get here a good night's sleep. Dick Toffel is our moderator. Dick has graduated not once, but 3 times from Harvard. A BA from Harvard, an MA in public policy from Harvard, and from the Harvard Law School. He served as vice president and assistant general counsel at Dow Jones and Company, and with their Wall Street Journal, he had roles of VP Corporate Communications, Director of International Development, Assistant Managing Editor, and Assistant Publisher, all at the Wall Street Journal. He is currently the founding general manager and president of ProPublica, which is a local news organization devoted to supporting investigative journalism. In fact, the thing they do, and they do it now to 20 news organizations in the country, is they fund the cost of some of the reporters and journalists covering or doing investigative reporting. And one on the personal side beyond that, I want to mention that his wife, Julie Seymour, is here. In Julie's first marriage, her husband is Thad Seymour, her husband was the son of Thad Seymour, the dean of Dartmouth College, and someone many of us who went to Dartmouth hold at the highest of regards. Without further ado, I'd like to bring forward RonNell, Andy, and Dick.
Good morning. Thanks to John Ferries for that, and thanks to John and Peter Bleiler for inviting me. Thanks also to my cousin Steve Toffel, who is here today, for suggesting it, and to my aunt and uncle, Joe and Dot Toffel, who are also here for hosting the 3 of us up here last evening. My uncle, it should be noted, co-founded this lecture series 22 years ago, so I am especially proud to be participating in it today. It's great to be back in Hanover. Both my wife and I spent many happy days here in the late 1970s, and from time to time since then, this is a magical place. Our announced topic this morning is free press, but that's very broad, so we're going to focus it quite a bit and spend our time discussing the nation's libel laws. the system under which people who think the press has unjustly harmed their reputations can seek redress. Let me quickly set the scene. As you know, and as John just mentioned, the First Amendment to the Constitution was adopted in 1791, just 2 years into George Washington's first term as president, and it declares in part that the Congress, quote, shall make no law abridging the freedom of the press. That's all it has to say on the subject of press freedom. The law of libel was a matter for state and common law and wasn't thought to have much to do with the Constitution until 1964, when the Supreme Court, in a case brought against the New York Times in Alabama over an advertisement placed by a civil rights group, held that it had a great deal to do with it. The court ruled that plaintiffs in libel cases who were public officials had to prove, essentially, that a statement damaging to their reputation was both false and had been published either knowing it was false or with some awareness that it probably was false. Along with the Pentagon Papers decision virtually prohibiting what we call prior restraints, that is to say court orders preventing an article from being published, this, the New York Times decision from Alabama, was one of the great press victories of the last century. In a series of cases over the 25 years after that, the court elaborated this new constitutional law of libel in substantial detail. And then it stopped. There has not been an important libel case in the Supreme Court in more than 25 years now. Under the current legal structure, I think it's fair to say that the American press receives more legal protection from libel than that in any other major country. To acknowledge my own bias as someone who runs a news organization, I think that's a great strength of this country. But we're here to debate today whether it's a good thing or a bad thing. Two people who think it's a bad thing are the current President of the United States, who has repeatedly said that he'd like to, as he puts it, open up the libel laws, and Supreme Court Justice Clarence Thomas. The President actually has no power in this area beyond the nomination of judges, and he has done nothing to follow up on his stated desire. In his own life, he has often threatened to sue for libel, but has only done so twice. The first he lost in part because the book in question was held to be true. The second case he withdrew. Justice Thomas and his colleagues, of course, do have substantial power on these questions. He said in February, in a concurring opinion refusing to hear a case involving Bill Cosby and one of his accusers, that the whole legal structure, erected starting with New York Times Company versus Sullivan, that Alabama case, was and is a bad idea and should be torn down. In other words, after 55 years of one regime of the constitutional law of libel, Justice Thomas proposes to start again. That is a highly debatable assertion, and it's enough, we think, to spark a strong debate. Our debaters, as you heard, are distinguished. They deeply disagree with each other, but they do agree, as do I, that the proper resolution of this question is critical for the press in our society and for society itself. So let's have at it. As RonNell is more or less making the case for the law as we have it today, we've agreed that she'll go first. Thanks again.
Thank you, Dick. And thanks to John and to everyone else with the summer series for inviting me, for being such wonderful hosts, and for drawing attention to the topic of press freedom in America, which I'm convinced is one of the most critical social and constitutional issues of the day. The tension that we're focusing on today, which asks us to consider how we will proceed when the First Amendment press freedom values butt up against these other values of protecting individual reputation, is a really, really complicated one. And I'll emphasize at the outset that although I'm a former journalist and one of the nation's most ardent pro-press scholars in the First Amendment realm, I am not at all blind to the reality that there are very real harms that are inflicted on very real victims in this area. Nor do I think that recovery for those harms should be barred. The question is not whether some remedy needs to exist for damage done through false and defamatory reporting. The question is how we, systemically, ensure that the remedy that's crafted aligns with our core democratic principles as a nation and ensures that we do not become, as I really believe our president has in mind, more aligned with countries in which public officials and other powerful members of the community use libel law to intimidate or stifle a free press and to curtail important public discourse. So to quote the language of the unanimous Supreme Court in that watershed 1964 case that Dick mentioned, New York Times versus Sullivan, whatever is added to the field of libel is taken from the field of free debate. That's the language from the court's opinion. Now, I want to spend the time that I've been given here this morning sort of parsing why that's the case, exploring some key theoretical and practical reasons why it is so, and emphasizing why this truth has driven us doctrinally to err on the side of free speech and free press in crafting many aspects of the law, from the specific elements that have to be proven by people who bring these claims, to the burden of proof in those cases, to the mechanisms used by appellate courts in reviewing them, to the time limits for bringing them, all of which I think are important, constitutionally imperative restrictions. So using the Sullivan case itself, we can see why this commitment to erring on the side of free speech and free press has been our lodestar, and also why it is critically important that it remain so in this era of really reckless attacks on the free press. First, the Sullivan case actually highlights for us the risks of creating a system in which libel law could be weaponized to shut down important conversations in our democracy. Some context here. The Sullivan case emerged in the difficult and often violent struggle for civil rights in the American South, where Black Southerners and their supporters were engaged in widespread civil disobedience, and the story of this movement was sort of carried through the nation through really a handful of prestigious northern newspapers, most notably the New York Times. And segregationist leaders in the South hated these newspapers because every day they were out there carrying these stories and pictures of another civil rights protest that was peaceful but had been met with violence, or some other illegal act by angry Southern whites, or worse yet, by city and state and county officials. On March 29th, 1960, the Times carried this full-page editorial advertisement placed by an ad hoc coalition of civil rights activists, and the ad leveled charges against Southern police forces, who the group contended had used force and violent tactics to try to quell these peaceful civil rights actions. Now, the basic thrust of the charges contained in the ad were true. But the ad was sort of riddled with these small errors. It said, for example, that the police had ringed the campus when they instead had lined up in front of it, or that the protesters were singing My Country 'Tis of Thee when they were really singing the national anthem, or that King had been arrested 7 times when in fact it had been something like 4, or that they had padlocked the dining hall when really they had barred entrance by some other means, not a padlock. But without any constitutional overlay, a libel cause of action at that time required the Times, placed the burden on the New York Times itself to show the truth of all the particulars, rather than on the plaintiff to show the falsity of the overall impression that was placed on readers. And so plaintiffs who were out there who wanted to stifle discussion of their own misdeeds really pounced on this system. L.B. Sullivan, who was a police commissioner in Montgomery, Alabama, and who wasn't even named in the ad, sued for libel and strategized to ensure that the case would stay there before an all-white, all-male state court jury that deliberated for less than 2.5 hours. And he won a $500,000 damage award, which at the time was a staggering sum, the largest ever in Alabama history, and enough potentially to bring even an organization like the Times to its knees. As Anthony Lewis described in his really superb book on this case, Sullivan's real target was the role of the American press as an agent of democratic change. He and other Southern officials who had sued the Times for libel were trying to choke off a process that was educating the country about the nature of racism and was affecting political attitudes on that issue. So if they would face these, crushing judgments for even unintentional errors, they would really have no choice but to stop writing about it. And this was exactly what Sullivan and others were counting on. So viewed in this light, Justice Thomas's recent assertion that Sullivan, and presumably the remaining framework of Fuller's system in which the tie goes to the runner on free press and open debate when there's a tension between it and defamation law, his suggestion that all of this should be rolled back can be seen as both practically dangerous and theoretically unsound. Thomas's primary argument for undoing this framework is a so-called originalist one. That is, in his view, there's no evidence that the founders themselves actively engaged to try to limit state defamation actions with the Constitution in this way. But of course, it was only in the Sullivan era that this pattern of using traditional defamation rules to shut down debate on matters of public concern really fully emerged, and that the conflict between these causes of action and our core First Amendment values became fully apparent. The founders' actual values, embedded in the First Amendment, suggest that they would be wholly on board with eliminating these opportunities for weaponizing libel law to squelch public debate. And that risk, I think, is a major reason to keep the press protective system that we have. Second, and relatedly, the New York Times versus Sullivan case introduced us to a critical concept that the court has often referred to as breathing space. This argument, and I think it's a powerful one, goes something like this. People who are debating matters of public concern cannot possibly get everything right 100% of the time. And angry, heated dissent is going to produce some defamatory falsehood. False statement, in the words of Justice Brennan, is, quote, inevitable in free debate, and it must be protected if the freedoms of expression are to have the breathing space they need to survive. So provable truth, the court is telling us, is just far too great an onus to be putting on people who are out there criticizing government or contributing meaningfully to dialogue on matters of public concern. Because if those burdens are imposed, people may well just self-censor. They'll just shut up altogether, rather than get out a really important gist that will be immensely valuable to democracy, or an important check on government, or the start of a useful conversation about powerful people in non-governmental roles. And this debate that we're having is actually really about how risky we are willing to make it for someone to contribute information to the marketplace of ideas. In the view of the Sullivan Court, if we let all the states be out there punishing errors about the official conduct of public figures, it would be antithetical to the purpose of the First Amendment. And the court wasn't, in saying this, suggesting that the values at stake on the other side of the scale are minuscule or that they're unworthy of attention, but rather that our more sweeping sort of structural values have to be what guide our jurisprudence in this area if we're going to maintain any willingness on the part of the press, or really the public, to keep talking. And here's where we get the real money quote from Sullivan. We consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks. In other words, we shield some speech, even some false speech, about public officials and other powerful members of society because we are concerned about incentives. If press speakers and public speakers fear that unintentional factual error could produce these devastating verdicts, or that even factually accurate criticisms could provoke really costly litigation, we face a far greater societal cost of chilling all Americans, not just the press, from engaging the issues that are central to who we are as a nation. In the aftermath of Sullivan, we should point out, we actually saw what a protected press could do with that breathing space when it dares to venture into this territory that it knows we should be discussing. We got the press coverage that Sullivan and others didn't want us to get of the civil rights movement. A decade later, we got Watergate. We are getting today investigative journalism that is spurring vigorous national debate on the president and his past and present associates, about the misconduct of powerful men who have mistreated women, about our nation's most pressing policies, about the behaviors and decisions of those outside of government who have power and influence to impact our lives. Unwinding Sullivan and its breathing space principle would unwind much of what we think of as central to the American national conversation. Third, Larger principles of self-governance underpin our Sullivan doctrine and dictate that we elevate these free speech and free press values over a desire to have easy libel actions. The British control from which we separated at the time of independence had a really pernicious system of so-called seditious libel laws, making it illegal, a jailable offense to criticize the crown, whether or not the dissent was valid or truthful. Just speaking ill of your government put you in jail. And in the early colonial years, a printer by the name of John Peter Zenger was jailed after his newspaper published several stinging attacks on the unpopular colonial governor. And the case became actually one of our nation's very most famous examples of jury nullification, because there was no doubt at all that Zenger was actually guilty under the contours of seditious libel as it existed, but his attorneys persuasively argued that no man should be punished for publishing criticism of his own government. And the Supreme Court's Sullivan opinion actually connects the dots on this history. It points very specifically to the widespread contemporary consensus at the time of the founding that our own very controversial Sedition Act of 1798, which likewise criminalized criticism of the federal government, was a violation of the First Amendment that we had quite specifically crafted to differentiate ourselves from that British system that we abhorred. And Madison and others spoke really vigorously at the time that the First Amendment's freedoms of speech and press, which we should note they themselves had just authored, protected a right to dissent, to criticize your government, even to do that less than temperately. It was one of our most central tenets as a new nation. And the Supreme Court in Sullivan was essentially saying that, stripped of its cover, L.B. Sullivan's claim was basically just one of seditious libel. It was a government official criticized for the way that he handled his public office, and a newspaper getting punished for publishing this criticism. So this effort to resurrect sedition law via a civil libel action wasn't constitutional, the court said. And this holding feels especially prescient in an era that now features an executive who derides as fake news any coverage that is unflattering, and who repeatedly pleads for the opening up of libel law in order to punish his critics who work in the press or his critics who speak through the press. Finally, and really importantly, the court in Sullivan and the cases that emerged in its aftermath teach us that we have a democratic obligation to turn to counter-speech as a remedy. So the thinking is that when public officials like Sullivan take a government post, the court said they've got to expect that their work will be closely scrutinized and even criticized by the people that they serve. It's a part of the deal. It's the cost of doing business in a democracy, the court said. And they have ample means, short of pursuing a crippling libel judgment, to rebut this criticism. They have easy access to the press to speak their side of the story, to deny allegations. The court in Sullivan is saying not only that this kind of speech is really important to debate in a democracy, but more importantly, that Commissioner Sullivan could have enhanced that debate. He could have added to that debate by holding a press conference or putting out a press release or otherwise contributing more truthful and more clarifying speech to the discussion, rather than just asking the court to shut it down and to punish the falsehood. He could have remedied the mistaken information without creating a system that squelches contributions of information altogether. This core idea, the idea that the best remedy for bad speech is usually more speech, is a First Amendment fundamental that the United States Supreme Court has clung to for the entirety of our jurisprudence. And it leads us to look closely at libel law in both of those factors that were true of Sullivan. First, his voluntariness of his exposure to the limelight, and second, his access to channels of counter-speech. And we look at those two factors every time that we're deciding how hard or how easy we'll make it for any given person to recover in a libel suit. And the Supreme Court has, I think rightly, in light of these values, held that the exact same rules apply to public officials who are like Sullivan, will also apply to non-governmental public figures who bring defamation suits. Subsequent cases playing out this doctrine involved plaintiffs who didn't hold any kind of elected public office, but instead held positions of fame or clear prominence in their communities. One of these guys was a university football coach. I will note as an aside that it was very easy for us at The Ohio State University to believe that this guy should be like the functional equivalent of the President of the United States for libel law purposes. In the Big Ten, nobody but nobody is more powerful or prominent or famous or able to garner attention than the football guy. The point here is that public figures, like public officials, usually do enjoy significantly greater access to the channels of effective counterspeech. And they have a more realistic opportunity, because of that, to counteract false statements than private individuals usually enjoy. Likewise, public figures generally have made the choice, the court says, to thrust themselves into the limelight and have thus voluntarily exposed themselves to the increased risk of injury from defamatory falsehood. The court says when you insert yourself into debates, and you seek and achieve fame, or you take positions that draw attention or become the topic of widespread, important public conversations and try to influence its outcome, we will expect you to use these other avenues to resolve your concerns about defamatory falsehood. And the barriers to a successful libel suit will, just of constitutional necessity, be higher for you. Today we see that these Sullivan values, and Sullivan itself, are under attack. And I would assert that never has there been a more important moment for preserving these principles. With an executive whose authoritarian instincts repeatedly and quite dangerously place the press in the crosshairs, and do so largely because he knows that if we fail to vigorously protect the press and its role, he can eliminate the counter-narratives and the core watchdog function that we count on the press to provide. If he can successfully construct the press as the enemy of the people and remove its protected status and its freedom and its incentives to investigate and to keep publishing, he really removes the primary barrier to his larger goal of enemy construction in other areas, his ability to vilify immigrants across the southern border or people of color in America's urban neighborhoods or the nation's own judiciary or its own intelligence community. And this is because it is primarily a free press, and the freedom to engage in critique without fear of crippling damage awards in the event of any factual error. It's that freedom that offers us education and factual retorts and historical context and the voices of the people who are out there thoughtfully investigating and challenging these enemy narratives from the executive. Justice Thomas is wrong. Sullivan and the wider structure of American defamation law that its principles support is wholly consistent with founding values, is deeply important to American democracy and self-rule, and is the fairest way for us to resolve the harms that are caused to individual reputation while still maintaining the really critically important incentives to speak and to publish on matters of public concern. So thank you all so much for your time. I look forward to a really engaging conversation with Andy and Dick and all of you.
Good morning. First of all, thank you to John and Osher for hosting. Thank you to Dick Toffel for moderating. And thank you to RonNell for a really entertaining and compelling argument with which I completely disagree. As you probably gathered from John's introduction, unlike RonNell, I am not a constitutional scholar. At least I've never been accused of being one. I'm not an academic. I'm a practicing lawyer. I'm a litigator. And I work at a boutique firm that specializes in representing clients who are adverse to the media or anyone who makes a defamatory statement about them. So we engage with the media pre-publication, post-publication, seeking corrections and retractions, and we draft, file, and litigate defamation suits. So I hope that that experience can bring a unique perspective to this debate today, because this is what I do every day, and I think I have a really solid ground level understanding of how the legal concepts, the high court rulings that we're talking about, how these things actually operate in practice and how they affect individuals. So I want to focus today on how these rules that we're talking about actually operate in practice, how they encourage, disencourage, incentivize, disincentivize activity, behavior in society by individuals and by the press. And I want to start, as the product of an American law school education, I want to start with a hypothetical, because that's what we do. So let's imagine that you are a middle-class professional in a small American city. We'll call you Jim Johnson. And let's say you're the sole proprietor of your own accounting business. You're not Arthur Andersen, you're small time, you represent your friends, small businesses in the community. You're respected, but you're not particularly famous or prominent or well-known. Now let's say that your small city is considering passing an equal pay ordinance, a statute that says businesses have to pay men and women in comparable positions the same salary. You, Jim Johnson, you've never been particularly politically engaged, but you think this is a great idea. Your wife is a successful, impressive woman. You have 2 daughters. Let's say they're in high school, and you think, this is the world I want for the women in my life. So you do something you've never done before. You write a letter to the editor of your local paper urging your fellow citizens to vote for this ordinance. And you say, as the husband of an accomplished woman, as the father of 2 wonderful daughters, I think it's important that we respect women, that we treat them with dignity, and that's why I urge you to vote for this ordinance. The paper publishes it. Your friends are impressed, your wife's impressed, you engaged in American democracy, you're pleased with yourself. But we're just getting started. Let's say there's a blogger in your city. He'd call himself a journalist. He's not maybe what you think of when you think of a journalist. He doesn't write for the New York Times or the Wall Street Journal. He runs his own blog. But it's pretty popular in the city. He writes on political issues, things going on at City Hall, so a lot of people read this guy. And let's say he leans libertarian, right? So he doesn't like the idea of government passing a law telling businesses what they have to pay their employees. He reads your letter to the editor, and he doesn't like that either, and he wants to take you down a peg or 2. So he does a Google search for you. Well, he finds that a Jim Johnson in this small city was accused of drugging and raping a woman at the state university 15 years earlier. Now, don't worry, it's not you. It's a different Jim Johnson. You attended a totally different university in a different state at a different time. And that discrepancy, the fact that you weren't that Jim Johnson, would have been obvious if this blogger had done any kind of investigation, if he'd looked at your bio on your work website, your Facebook page, your LinkedIn page. It should have been obvious. But this blogger, he was looking for dirt on you. He thought he found it. He thought he hit pay dirt. He didn't do any investigation. He rushed to publish. He wrote a blog post that said, that Jim Johnson who wrote that letter to the editor talking about how he respects women and wants them treated with dignity, did you know he raped and drugged a woman at university 15 years earlier? Let's say he includes a picture of you in front of your business. So he's got not only your photo, but the name of your business on this blog post as well. Like I said, a lot of people read this blog, and it's 2019, right? So it goes viral. People are sharing it on Twitter, on Facebook. They're emailing it and texting it to their friends. So even people who don't read this blog, they hear it, they see about it. In no time at all, you are Jim Johnson, the rapist. That is how the public thinks of you. You get dirty looks on the street. Tax season comes around, but your business dries up. People don't want to work with an accounting firm run by a rapist. You try to tell people it's not true. Your family and friends, they know it's not true, but that's a small circle. You don't have a popular blog. You don't have a microphone to counteract the lie and get the truth out. There's an old saying that a lie gets halfway around the world before the truth has a chance to put its pants on. And people's minds are made up. They believed it. A journalist said so, said that you were a rapist. This affects you deeply. We talked about the economic consequences, but imagine the stress of it. You can't sleep. You're having panic attacks. Your daughters, the ones you wrote the thing for in the first place, they come home from school crying because everyone's talking about what a bad guy their dad is. Your wife knows you're innocent, but the stress puts a strain on your marriage. What are you going to do about it? Well, you might think, I'm going to sue this guy. I'm going to get redress for the harm to my reputation, for the economic harm that he's caused me, for the emotional distress that he's caused me. So you hire a local lawyer, personal injury guy, right? He's not a defamation expert, but a tort's a tort. And he says, well, let me look at the elements of defamation. A false statement that was published about you negligently that caused you harm. We're good to go. You should be all set. Let's do this. you should be due substantial damages. Great. You file a complaint in your local courthouse alleging that this blogger defamed you and seeking damages. Sounds like a no-brainer. And you allege, accurately, that what this blogger did was negligent. Not just negligent, grossly negligent. I mean, he failed to conduct any investigation. He was biased. He rushed to publish without confirming facts. He was literally motivated by a desire to smear you, and he caused you enormous damages. So great, you're off to the races, right? Wrong. Your case gets dismissed immediately. Literally tossed out of court on a motion to dismiss before you even get a chance at discovery, let alone to present your case to a jury. Why? Well, the blogger argues in a motion to dismiss, and the court agrees, that even if what he did was totally negligent, even if it was grotesquely negligent, that's not good enough because you, Jim Johnson, are a public figure, and under Supreme Court precedent, that means that you have to show that that blogger acted with actual malice, that he knew it was false when he said you were a rapist. And remember, the facts are, he thought you were a different Jim Johnson. He was grossly negligent, but he didn't actually know at the time he published. Now you think, wait, I'm just a random local guy. I'm just a small-time accountant. How am I a public figure? RonNell just told me that that's the football coach of The Ohio State University, someone who's really famous. That's not me. I'm a nobody. How could I possibly be a public figure? How could I be subject to this onerous actual malice standard? Well, the court says, when you decided to write that letter to the editor of your city paper, you injected yourself into an ongoing public controversy concerning this equal pay ordinance. By doing so, you essentially made yourself a target. You invited scrutiny and criticism, and you brought on the risk of defamatory falsehoods being published about you. So showing negligence like you would in almost any other tort case, car accident, medical malpractice, slip and fall, not good enough. You didn't plead facts showing that that blogger knew it was false when he published it, so you lose. Wait, the court's not even done with you yet. You live in a state that has something called an anti-SLAPP statute. And we'll probably talk about these a little bit later today. SLAPP stands for a strategic lawsuit against public participation. An anti-SLAPP statute, which I believe 29 states have some variation of at this point, is basically designed to disencourage defamation suits in the first instance and to encourage courts to get rid of them quickly. Many of them also contain cost and fee shifting provisions. So your case is going to get adjudicated at an early stage, and if you lose, you're going to pay the other side's attorney's fees. So the court not only dismisses your lawsuit, but he orders you to pay the blogger that falsely accused you of rape $50,000 in attorney's fees and costs. That, ladies and gentlemen, is the state of defamation law in America today. My argument, in a nutshell, is one, I'm not anti-free press. I don't think anyone in this room thinks of themselves as being against the free press, and we all agree that freedom of the press is a good and important thing. But there is a tension between freedom of the press and the importance of one's reputation and the ability to seek redress for harm to your reputation, and a balance needs to be struck there. In 1964, the Supreme Court entered this arena, essentially federalized defamation law, and defamation law is a state law cause of action, always has been. It's a common law tort. The Supreme Court steps in 1964, says the federal government is going to take over and decide what defamation law should be. And my belief is that they struck the balance incorrectly, that the actual malice standard from the New York Times case is wildly overbroad, punitive, strikes the wrong balance, and really impacts individuals' ability to not only seek compensation and redress, but even to correct the lie. And the lie lives on because of the harshness of this rule. We need to call the actual malice rule what it is. It is essentially an immunity from liability for even grossly negligent conduct by the media, or by anyone, frankly. We're focusing on the press today, but this rule applies to anyone, any defendant, and I think that's a really important thing to think about in this day and age with the internet. What is a journalist now? We used to think of a journalist as, a guy with the top hat and a notepad who works for the New York Times or the Wall Street Journal. Well, now anyone with access to the internet can be a journalist. They can run a blog, they can run their own news website. And standards are eroding because of that. Even if we trust the New York Times, do we trust the blogger to self-police? And that's really what we're talking about here. I think it's a fascinating thing to have an entire professional class, journalists, and the companies they work for, which, to be clear, for the most part, are for-profit, large national or multinational corporations. It is a fascinating thing to have them arguing that they should essentially be immune from liability when they screw up and really, really hurt people. And for some reason, when it's journalists, I think that we've been conditioned to think, well, journalists are important, the press is important, so maybe a different rule should apply to them. But if it was Monsanto or the tobacco companies or pharmaceutical companies arguing to you that they should be immune from liability even when they do something awful that really, really hurts people, I think you would be pretty wary of that. And I think that that same skepticism ought to apply to the press. A couple quick points. Again, I want to talk about how this rule works in practice. So I want to hit the Sullivan case and a couple follow-on cases to show not only what the actual malice rule is, but how it's been expanded. And that's what tends to happen with precedent, right? The Supreme Court jumps in, it says, here's the rule, but sometimes that rule is a little vague or it doesn't give a lot of detail. So it's left to the lower courts over time to flesh it out and say, what does this mean? And that's what's happened with the actual malice rule, and it's expanded. So New York Times v. Sullivan, 1964, the Supreme Court says public official defamation plaintiffs have to prove actual malice, which means knowledge of falsity or a reckless disregard for the truth. In a couple follow-on cases, Curtis Publishing in 1967 and Gertz v. Robert Welsh in 1974, the court expands this rule to not just public officials, but now public figures as well. In St. Amant v. Thompson in 1968, and I think this is a really important case, the court says, well, that reckless disregard part of the test, what that actually means is, quote, the defendant in fact entertained serious doubts as to the truth of the publication. So what sounded like a two-pronged test, right? Knowledge of falsity or reckless disregard for the truth. The court has really read the reckless part out of that. You cannot sue the media in an actual malice case arguing that they were grossly negligent or even reckless. The test has merged into the same thing, which is you have got to prove that they knew it was false when they published it. Finally, in Andersen v. Liberty Lobby, 1986, the court imposed an onerous standard on summary judgment for defamation plaintiffs. So very briefly, life cycle of a civil lawsuit, right? You file a complaint. If you survive a motion to dismiss, you go to discovery, the parties exchange documents, they take depositions, and then before you get to trial, before you get to the jury, there's something called summary judgment. And this is where the parties argue to the judge basically whether the jury should be allowed to hear the case or not. In a typical civil case, the rule is there a genuine dispute of material fact? Basically, is there a disputed issue that's a toss-up, such that the jury, and the old saying is, judges decide the law, juries decide the facts. So is there a factual toss-up such that the jury should get to hear this case and decide the winner? In a defamation case, the standard is different. It is not genuine dispute of material fact. At summary judgment, again, before you get your case to a jury, you have to prove to the judge that you can show actual malice, knowledge of falsity at the time of publication by clear and convincing evidence. So basically, the judge acts as a gatekeeper, and you have to show to him that you win before you ever get to go to the jury and see if you win. And that applies post-trial as well. Even if that judge is convinced, finds it convincing and clarifying and all that, and sends it to the jury, an appellate court's going to look at that afterwards, and they're going to make their own judgment of just how clear and convincing your evidence was. So it's an extremely high bar, not just the actual malice legal standard, but how you have to prove it, the level to which you have to prove it, and whether you can ever get it to a jury. So how hard is this standard actual malice to prove? How hard is it in practice? It's nearly impossible. Again, we talked about in a typical tort case, the standard is negligence. That's failing to act reasonably, failing to take reasonable precautions, failing to do what a reasonable person or company in your position would have done. And that's an objective standard. And in a private figure defamation case, that is typically, with some exceptions, that's typically going to be your standard. But if you're a public official or a public figure subject to this actual malice standard, negligence is out the window. Again, you have to prove knowledge of falsity at the time of publication. How are you going to do that, right? It's a subjective standard. So you're being asked to prove what was in the mind of this journalist at the time he published this story. And when you're arguing this at summary judgment, right, it's like probably 2 years later, or even during discovery. It might be, the story was probably published 2-3 years ago. So to say what was in that journalist's mind at the time of publication, you have to be both a mind reader and a time traveler. And imagine how you're going to do that, right? Do you think that any journalist in a defamation suit has ever sat in a deposition or gotten on stand at trial and said, yeah, you got me. When I published that, I knew it was false, but I did it anyways? Of course not. That's not going to happen. They're going to swear up and down that they were convinced, certain, that they had absolute faith in their story at the time they published it. They're going to swear out affidavits to that effect. Their editors are going to do the same. So you're already up against the fact that you have to prove what was in someone's mind, which is kind of an impossible thing to do. And you're going to be up against a reporter who's going to swear up and down that he believed it was true. So just briefly, the courts recognize this, right? I'm not just saying this. The courts recognize this is pretty much an impossible standard, and if you're a plaintiff in an actual malice defamation case, you're basically going to lose. Courts have called it, quote, a heavy, often insurmountable burden, a high bar that public figure plaintiffs rarely surmount, a difficult task that extracts a high price from the victims of defamatory falsehood, such that many deserving plaintiffs, including some intentionally subjected to injury, will be unable to surmount the barrier of the New York Times test. And the cases, I'll tell you, as a practicing lawyer, often you're looking for precedent to cite, right? You're arguing a motion to dismiss or a summary judgment case, and you say, well, I got to cite cases to the judge. I need to find cases that support my argument. It's almost impossible to find actual malice cases that support the plaintiff's argument because every case comes out the other way. On Westlaw, when you're doing research, you're seeing opinions on motions to dismiss, opinions on summary judgment. Everyone goes against the plaintiff. And they don't talk about, well, what kind of evidence is actual malice? It's all framed the other way. It's what's not actual malice. So a journalist's total failure to investigate his story before publishing it, not actual malice. Failure to reach out to the story subject before publishing to get their side of the story or offer them an opportunity to meaningfully dispute what you're about to write about them. Nope, not actual malice. Failure to follow journalistic standards or ethics or your own media entity's internal policies and standards. No, not actual malice. Relying on an anonymous source without any real idea of whether that source is credible or knows what they're talking about. Not actual malice. Now, I want to talk briefly, and I know I'm getting a little short on time, so I'll go quickly, but we've talked about how hard the actual malice standard is to prove. I want to talk about who has to prove it. Because I think when we talk about public officials and public figures, we use the football coach example, or RonNell referred to elected officials like the president, right? Most of us in this room probably agree that we think that in America you should be pretty unfettered in your ability to criticize the president. He's a big deal, he ran for office, like obviously he accepted some of that risk. But these are vague terms, right? What does public official mean? What does public figure mean? Again, these have to be fleshed out by the lower courts who have to define these terms and apply them to specific situations. So how are they applied in practice? Well, here's some examples of individuals that courts have found to be public officials and thus subject to the actual malice rule. A taxi cab inspector in Charlotte, North Carolina, a county engineer for Allen County, Ohio, a social worker employed by the Alameda County Social Services Agency, a municipal building inspector for the city of Ansonia, Connecticut. Are these the kind of people we thought about when we thought of who a public official is? Some of us in this room, or at least friends or family, probably worked for municipal or state governments, maybe in positions that didn't have all that much authority. Maybe they weren't elected positions. These are just working people, right, who happen to be employed by the government. Well, what we've done is applied a standard to them that essentially makes the media immune from defaming them, no matter how harsh and false the statement was. The standard has been applied way down the rungs of government employees. Public figures, so RonNell mentioned this, there's two kinds. There's a general purpose public figure, and there's what's called the limited purpose public figure. That was the guy from my hypothetical who supposedly thrust himself into a controversy. So general purpose public figure. That must mean someone who's really famous, right? Like Hollywood celebrities, super rich people. Jeff Bezos, he's probably a public figure, makes sense. Well, here are some examples of people that the courts have found to be general purpose public figures. And this means that whatever the media says about you on any subject matter, any false statement, whether it's about your personal life, your professional life, for all purposes, you are a public figure and you have to prove actual malice. A regional vice president for a telephone company, an amateur surfer who frequented a beach in Oahu because he was known for tackling really dangerous and difficult waves. That was a District of Hawaii case, of course. A track coach at a small university. A horse jockey in New Jersey. Public figure for all purposes. Real quick, limited purpose public figure. To put my cards on the table, I think this is the aspect of the Sullivan ruling that is the most ripe for abuse, that has most incorrectly struck the balance, because at the end of the day, it is shocking how easy it is to become a limited purpose public figure. Courts strain to find that you are. They add up Google search results. Do you have a website for your business? Have you taken positions on social media? You yourself can be a limited purpose public figure even if you don't think of yourself that way. Example, it's a Minnesota case from 1993. The owner of an apartment building was a limited purpose public figure because by owning an apartment building, he thrust himself into a public controversy concerning rental housing. A professional belly dancer was a limited purpose public figure because she sought publicity for her services. A female Navy fighter pilot was a limited purpose public figure with respect to the controversy about women in combat because she chose to be both a woman and a fighter pilot. And an example from my own practice, an associate dean at the University of Virginia, who I represented in a lawsuit several years ago against Rolling Stone magazine. Some of you may be familiar with the gang rape at UVA story that Rolling Stone published. Our client, Nicole Aramo, who was one of many associate deans at the University of Virginia, was found to be a limited purpose public figure because she had previously given an interview to a student journalism project that was asking about the university's Title IX procedures and how they handle sexual assault complaints. So she had thrust herself into that public controversy. All right, I'm getting the hook here, so very, very quickly, I just want to touch on the countervailing consideration here, right? We all agree freedom of the press is a great thing. Maybe we don't think so much about reputation and how important reputation is. And like the song says, maybe you don't know what you got till it's gone. But every day in my practice, I see people who have seen their reputations shredded by false statements in the media, and I have to tell them, there's nothing I can do for you because of this actual malice standard. And the last thing I'll point out is, historically in America, reputation has not been such a secondary consideration. A number of state constitutions actually refer specifically to a right to reputation, right up there with those other inalienable rights like life, liberty, and property, specifically Pennsylvania, West Virginia, Louisiana, Arkansas, Florida. These constitutions going back to the founding of these states all recognize the importance of reputation. I'm out of time. It's something I'm sure we're going to talk about more in today's debate. So once again, thank you everyone for coming, and I look forward to it.
That was terrific, I think, on both sides. Thank you both very much. We've got about 15 minutes, and I think we're going to probably get time for about 2 serious questions. So I'm going to come back to your public figure point and put it to RonNell in a minute or two, so you can, that's coming. So, but first, Andy, and this obviously before we get to your questions. So regarding, I want to shift the focus a little bit, and I want to come back to all of our mutual friend, the President of the United States. Regarding the only libel suit of his that ever reached a conclusion, the Washington Post reported that President Trump said in an interview, and this is a case, by the way, that he brought as a private businessman before he ever announced his candidacy for president, many years before. Anyway, he said in an interview that, quote, he knew he couldn't win the suit, but he brought it anyway to make a point. I spent a couple of bucks on legal fees, and they spent a whole lot more. I did it to make the author's life miserable, which I'm happy about. And so my question is, if we relax the libel laws, what, if anything, do we do about rich, powerful people just doing more of that and with greater consequence?
Sure. So a couple of things. We're here today to talk about the actual malice standard. There are other ways to counteract what Dick is talking about, which is this notion of powerful people suing the media just to make them spend the money in the hopes that that'll get them to shut up. One example I already mentioned, although I'm not the world's biggest fan of them, are anti-SLAPP statutes, which you're of course familiar with. And the whole idea, and some are written better than others, some are way too broad, but the core idea of them is to allow the court to adjudicate, at least at some level, the merits of a defamation case early on. Some of them apply almost a summary judgment-like standard at the motion to dismiss stage. Now, I have a lot of problems with that, with the really aggressive ones, because you're basically being asked to prove your case before you've even had an opportunity to take discovery and learn facts, which is like literally an impossible thing to do. But there is, I think, some merit to the idea of weeding out these meritless lawsuits right at the outset, where it's pretty crystal clear that that's what's going on here, that the statement itself isn't actionable, maybe it's opinion, maybe it's not of and concerning the plaintiff, maybe some kind of privilege applies. And there are many, many privileges that apply to the media in defamation suits. And one thing I want to talk about today is, the breathing space that RonNell mentioned. There's a lot of breathing space independent of the actual malice rule. There are so many hurdles for a defamation plaintiff to surmount, separate and apart from actual malice. So that breathing space exists independently of actual malice. But the short answer to your question is something like an anti-SLAPP statute. That is the very idea, that you can weed out those suits early on, that you can have cost shifting in fees to essentially penalize people for doing exactly what you're talking about.
Just one quick question to follow up. Would you also be in favor of it? It's an issue we haven't talked about a lot, although RonNell adverted to it. Would you, and now the defamation laws put the burden of proving that a statement was false on the plaintiff. Are you comfortable with that?
Absolutely.
Okay.
Simple answer.
So RonNell, let's...
Absolutely not.
Yeah. Let's...
Debate over.
Right. Let's get back to this public figure question, which I think almost everyone agrees is the most controversial part of the current libel law regime. More than 30 years ago, a federal appeals court judge said that trying to define what constitutes a public figure is, quote, like trying to nail a jellyfish to a wall. It hasn't gotten easier in the last 30 years, and given that difficulty, which has led to not only some interesting, as Andy outlined, but actually literally, as you know, inconsistent results from state to state, and given that the Supreme Court's last word on this particular subject came 40 years ago, how do you justify special treatment, that is, less protection for their reputations, for public figures not of the level of the football coach of the Ohio State University?
Right, yeah. This is the Jim Johnson question.
Right.
Right, and Jim is our most conceivably sympathetic plaintiff, right? We have just constructed the outer edge of the dynamic with Jim. And I think it's worth noting, I mean, people do prevail on, I concede that the actual malice standard is incredibly difficult, the kiss of death in many, many cases, designed by the court in Sullivan to be the kiss of death, to force you, L.B. Sullivan and others, into a conversation in the wider marketplace of ideas rather than to move to a libel judgment to engage this matter. People do prevail on it. In fact, I'll just do some free advertising for Andy's law firm. If you go to the website of Andy's law firm, you will see representative matters that are depicted there that show multi-million-dollar damages, including the woman in the Rolling Stone case that he described, who was not a public figure in the sense that my university football coach was, or the President of the United States was, who was certainly not famous. We didn't all know her name prior to this. She had thrust herself voluntarily into matters involving Title IX. She was the person on campus who was important to questions of sexual assault and to whom you would report sexual assaults at UVA campus. And there was a brewing concern about sexual assaults on university campuses, including UVA, which some people had raised concerns about legitimately prior to this truly false and staggeringly problematic Rolling Stone article. And his firm won a multi-million-dollar we don't initially, right? We don't know what it settled for afterwards, but there was a verdict at that stage where she prevailed in demonstrating actual malice and recovering in that. There are other examples, really impressive examples. They're the best firm in the country for a reason on this, right? But winning millions for a former director in a defamation action filed against a publicly traded company for false and defamatory statements in a proxy statement, a person who I've never heard of and who you've never heard of and who is famous, maybe more famous than Jim Johnson, but not famous in the widespread famous way, but who was a public figure for purposes of that case. And that's a big piece of what's happening here that I think is really important for us to appreciate, is that our taxi cab inspector or our municipal building director or our slumlord isn't a public figure for, the court is also taking into account the nature of the story that gave rise to the alleged libel. So if this libel came up in a context involving something having to do with the taxi system, or something having to do with your slumlord status, or something having to do with the, I can't remember the other ones, belly dancing industry, then we're saying we're having a public conversation about this, and presumably the newspaper that ran your letter to the editor would also be very interested in writing a story about the fact that the dialogue that has continued in this ongoing dispute it turns out that people have been saying things that are false. It turns out that there's information that needs to be clarified. It turns out that there's an ongoing conversation here. Constitutional law is slippery. It's jellyfish-like in a wide variety of ways. This would not be anything close to the first constitutional standard that we had that had to be played out in various ways in various courts across the country, and that doesn't have perfectly definable standards. Lawyers across the country are doing the sorts of things that Andy is doing, which is looking for cases in Westlaw and elsewhere that are similar to this and that give us the contours of what counts and what does not count. So the lack of perfect clarity about who will or will not be deemed a public figure isn't, in my mind, uniquely problematic as a constitutional matter. The erring on the side of ensuring that we demand people engage in counterspeech when the matter is a matter of public concern, even if it's for a small public. So the surfer, for example, isn't a matter, he's not a guy that we all think of as famous universally, but in that surfing community, he may well be an all-purpose public figure. Everyone knows about him. He can engage the media in ways that he can have a press conference out on the beach or call up all of the local beach the bloggers who cover surfing and has access to those avenues of counterspeech, and decided that he wanted to be a part of that national conversation. Democracy is really, really messy, and I have incredible sympathy for people who find themselves spoken of falsely and spoken of sloppily. But that's what negligence is. The negligence standard, if we ratchet the standard down, negligence is a standard of failing to exercise reasonable care. That's what if you proceed on a bare negligence standard, it's that we think, what would reasonably careful people have done? And you failed to behave as a reasonably careful person would have done. Conversely, the actual malice standard is much stricter. It requires that you knew or that you recklessly disregarded, you were faced with the subjective awareness of the probable falsity of this, and you moved forward. And when people do that, Andy's firm wins on their behalf. When you can demonstrate that this blogger set out with an agenda, like the Rolling Stone, a huge piece of the argument in the Rolling Stone case was this reporter
came to campus with an agenda, wanted and sort of disregarded all of the facts on the way to her conclusion because she wanted to prove that colleges weren't taking this seriously, and so she didn't follow up and didn't take care to get things done. In those circumstances, they are rare. I'm just pleased that they're rare. I think the Constitution demands that they be rare.
I think we have time maybe for one more quick one before we go to break and take your questions. Andy, the news media is increasingly national. The internet obviously is driving this. Cable television has also driven it for even longer. If we eliminate constitutional standards for national figures in national media, we will have different laws in every state. Why is that a good idea?
Well, that's democracy, is the short answer. I mean, the alternative is federal fiat deciding what state laws should be, and that doesn't just apply to the defamation context. You can apply that to any context. I mean, it's the laboratory of democracy concept where we recognize in our federal system that states can choose to address issues differently and can have different laws. You know, if my position were accepted and the actual malice standard was tossed, at least from a federal fiat level, the states would still be free if they chose to impose that standard. And you know, I think part of what you're getting at is the concern about forum shopping, right? It's like we have different rules in different states, so people are just going to run to the easy states to sue. That issue sort of already exists and has already been addressed because, you know, again, separate and apart from the actual malice standard, different states have different laws on defamation. They have different privileges, different rules. They may have an anti-SLAPP statute, they may not. So there are different rules in different jurisdictions regarding defamation cases. That's just a fact of life, and that's true of almost any cause of action. One way the courts have addressed that with national publications is personal jurisdiction and how you obtain jurisdiction over a defendant in a given jurisdiction. And courts have created rules to say, well, just because something was published on the internet, meaning it was published everywhere, doesn't mean that you can go sue this guy in Alabama because people read it in Alabama. There has to be a tighter nexus. The defendant has to be there. They have to have purposely directed their reporting activities into that state. So to answer your question, I would say that differences in defamation law already exist state by state, and the courts have already begun to construct ways to deal with the forum shopping problem.
Can I give the 2-minute response to the federal fiat question?
Please.
Okay, I will. I'll time myself. The constitutional scholars' response to the question of federal fiat and the federal takeover of defamation law that should be state-based is that this is what the Bill of Rights does. We have long since concluded that constitutional law it applies to the states. It's incorporated against the states. And the states, no less than the federal government, are bound by the First Amendment to observe our First Amendment rights. They do not have the freedom to violate our First Amendment, to use their courts to violate our First Amendment rights any more than they have the freedom to use their courts to discriminate against us on the basis of race or gender or sexual orientation, or to violate our freedom of religion or any other right that we have. The First Amendment protects against encroachments by state governments as much as it protects against encroachments by the federal government. And the court in Sullivan, and in other cases, has said every branch of government is precluded from violating our First Amendment rights, including our courts, making themselves a vehicle for private suits to do this against us violates the First Amendment. It's not a federal takeover in the sense of federal fiat in a larger sense. It's an interaction between state common law and federal constitutional law. And our federal constitutional system is that the federal system is supreme.
Okay, John, do I send us a break or do you? Yeah, so we will be back here at 10:45, 10:45, and we very much welcome your questions by card and otherwise. Thank you very much.
Okay, everybody is pretty much seated, so we will resume. One thing I have to mention, apparently I made a mistake in thanking our underwriters, and I omitted Wells Fargo. And I want to state now, thank you, Wells Fargo.
All right, welcome back. Thank you all for being here. I just wanted to say we heard from a number of people, which is frankly strikes the three of us as extraordinary, that among the folks in the audience for the first part of this, and probably not at the moment anymore, but nevertheless was Justice Stephen Breyer of the United States Supreme Court. So I think it is important to say that even if he's not still here, I'd hope you all join me in thanking him for a lifetime of distinguished service to this country.
He's an all-purpose public figure.
Yeah, as well as a public official, and having been there for 25 years, if he doesn't like the law, he has no one to blame at this point but himself. I thought we'd start with a little bit of a lightning round because some of these questions are both good and also easy to answer, and have definitive answers. Or at least relatively brief answers, so let's sort of riff through a few of them. The first comes from the live stream from the University of Vermont, and this is for either of you, obviously. Do comments on Facebook or Instagram mean one is inserting themselves into the realm of public opinion?
In terms of making yourself a limited purpose public figure, the answer is very possibly yes. It's going to depend on context and the issue, but absolutely, I think that's one of the concerns, that even social media commentary can make you a limited public figure.
Yeah, I agree with the portion on which it is deeply contextually driven. What happens online in terms of our conversations about matters of public concern doesn't perfectly, to the extent that it's my friends chiming in on my Facebook page on my picture of the chicken sandwich that I had for lunch. It is not. That's a hypothetical that involves my sister. But you can imagine contexts in which we engage online in ways that are this sort of new frontier of where we used to engage in newspapers or in other public fora, and now we are moving into a place where the law is trying to map itself onto new technology. I think it's developing.
To prove knowledge of falsehood, can the plaintiff gain access to the defendant's private notes?
That is an excellent question, and that is not a short answer, but I'll do my best. So, fascinating, right? Like, you're being asked to prove what was in the journalist's head at the time they published this. The only way you're going to do it, and the courts have recognized, the Supreme Court has even said, you're never going to prove, awareness of falsity from the mouth of the defendant, of course. The only way to do it is circumstantial evidence, which is typically things like that, contemporaneous notes, email correspondence. The problem is, and I mentioned before that there are many other hurdles in a defamation case for the plaintiff other than the actual malice standard. Many states have journalist shield laws or journalist privilege statutes, and some federal circuits recognize this as well, a qualified privilege for journalists, which makes a journalist's internal documents, news gathering materials, notes, emails with their editor, drafts, basically akin to what we would think of when we think of the attorney-client privilege, right? Like if I speak with my attorney about something confidential, that's privilege, that can't be produced in discovery, the other side can't see that. There are state statutes and common law rules that say that a journalist's notes are the same. Just as an example from real-world practice, I'm currently litigating a case against CNN in the Southern District of Florida. Their journalist privilege log in that case is 449 pages long. And that's not one document a page. That's like every page is a spreadsheet with row after row of documents. So literally thousands and thousands and thousands of their internal communications, contemporaneous communications that we need to prove our case, they are withholding under a claim of journalist privilege, and that happens all the time.
You can have me back someday to talk about the importance of reporters' privilege and the importance of protecting journalistic work product, particularly in a dynamic in which journalists are the subject of attack by people in power in the government. Our history is actually quite clear about the importance of these shield laws, but I will give away a little something on Andy's side of this, which is that not only does getting those notes or those recordings not only is it difficult to get those notes and those recordings, there's actually case law from the United States Supreme Court that suggests that there might be circumstances in which you would have a recording, right? We tape recorded the interview, and I, the journalist, put something, not I, we're going to put this somebody else. It doesn't have, I don't even make myself the bad actor here. A hypothetical bad journalist put something in quotation marks and said, comma, Jones said, after those quotation marks. And we listened to all of the hours of recording, and Jones never said those exact words. Even that doesn't count in all circumstances as knowing falsity or reckless disregard for the truth, because if the gist is the same, or if the nub of what was conveyed is accurate, the court always wants to err on the side of making sure that it isn't urging journalists to engage in self-censorship.
Here's one from the stream from the University of Kentucky. In elections, the press is required to provide equal time to coverage of opponents' views. By the way, that's not really true anymore. But are there similar requirements to give equal coverage to a person who claims to be defamed?
Absolutely not. No judge in this country is going to order a journalist to even issue a correction, a retraction, or a follow-on story. The courts think that is not their job to tell reporters what to report. So no, and I think that's one of the concerns is if you create what is essentially an immunity from liability, you take away the prospect of legal risk, and legal risk is a powerful incentive. If a journalist publishes a false story and knows they can be held accountable for it, they're more likely to issue that correction, which, by the way, for them is a black eye. They don't want to do it. Journalists don't like issuing corrections because that says to the world, I screwed up. So how do you get them to do it? Well, legal risk is a really effective lever to drive behavior, but in this arena of the law, we've essentially eliminated it.
And I can give you a two-word answer for why we have refused to have court orders of what should appear in the newspaper. First Amendment. It is a really dangerous practice to get in a position where we say that courts, branches of government, can order content to appear in a publication that a publication has not chosen. And when we break down those barriers and come to a place where forced publication by the government is no longer prohibited, it's a pretty slow slide to the government forcing publication of a wider variety of things that are inconsistent with our democracy. It is the case that a publication of a retraction or a clarification or you see them, right? You've seen them in the newspaper. Often what's happening there is an attempt to, they are incentivized in the way that Andy's talking about, to try to stave off larger damage awards, right? So in some circumstances, having done so shifts what happens at the damages stage.
I just want to take the moderator's privilege for one moment about corrections. In my experience in 35 years in this business, reporters don't like corrections. Good editors, when mistakes are made, do like to publish corrections.
As a matter of institutional reputation?
As a matter of institutional reputation, as a matter of disciplining people in a way that they feel professionally so that you minimize the numbers of them. And I think that you would, as news consumers, be well served to regard places that issue corrections as generally that's a good thing, and places that don't, and my number one favorite target here is always the evening news show, the network evening news shows, on which you have essentially never in your lives seen a correction. It is not because they have never made a mistake, and frankly, I think it's an outrage.
Yeah, a couple of years ago, was it a couple of years ago? Maybe 6 months into his presidency, President Trump, you might remember, pitched that there was going to be these sort of Oscar awards for bad journalism, right? He was going to point out that the fake news were terrible and the wide variety of ways in which they can't be trusted and are terrible. And I had a piece that I was moving to publication that I actually had to hold because I really thought this was going to be some big blow-up moment between him and the press, and I needed to make sure that I wrote about it. And I waited and I waited and I waited. It was pretty clear that he hadn't told any of his people internally that he was going to do this, and then they were surprised with the fact that they had to come up with some top 10 list of the worst journalists in America. And something like 9 of the 10 that he listed, the mechanism by which he was highlighting for us that they had committed error was that they had apologized for or corrected error. And I just think that's a really short-sighted view of how we want journalists to behave, right? That we're sort of going to slam them publicly for having corrected the public record. That is the way that we want the marketplace of ideas to work and the way that we want counterspeech to operate. And so this sort of tension between the executive and the press is happening at a level that I think is deeply problematic in terms of incentives.
So I agree with that. I think a couple points. One, Dick is right that good editors like corrections, but you're relying on the fact that when it's you who's been defamed, there's a good editor on the other side of that letter. Also, it's not always the editor responding, it's often the lawyers. These big media companies have lawyers, and lawyers don't think like journalists, lawyers think like lawyers, and they think in terms of legal risk. And I can't tell you how many letters I get back from media company lawyers saying, I mean, yeah, they say like, oh, well, we think our story was accurate and true. Then they spend 2 pages on how I can't prove actual malice. And what does that show you? It shows you that they're thinking about how they should act in terms of whether they're exposed to legal risk or not.
I'm going to let that one go, but I am one of those lawyers. And
Me
I
too.
try not to behave that way. So a number of people in the audience approached me at the break, and we have a question about opinion. So I just want to, we haven't talked much about opinion, and it's worth getting just sort of a statement of the law here. But let me read the question. Could you talk about the Oprah Winfrey hamburger case? She is clearly a public figure, I think we'd all agree about that, and she said on a TV program that she would never eat another hamburger. Is expressing one's personal opinion ever seen to be malicious intent?
So the Oprah case, is nuanced, and I won't get into the details of that. Some states have different laws that apply to like disparagement of like food products, so that's a little bit different than just a defamation case.
These have the wonderful name of ag-gag laws.
Exactly right.
You can appreciate that libeling a hamburger is different than libeling a human being. That's all we're saying.
Human beings get less protection than hamburgers, is the truth of it.
Which gives you some sense of the power of the agricultural lobby in this country.
But in general, one of the things I mentioned earlier is that does the press really need the breathing space of the actual malice rule, because there are all these other defenses. Opinion is a defense you're always going to see in a motion to dismiss in a libel case. It's really broadly defined, and it is protected. I'm not sure what else to say about that, but generally you cannot be held liable for stating an opinion unless that opinion conveys false facts or suggests to the reader that you're aware of facts supporting your opinion that you're not disclosing. But as a general matter, robust protection for any statements that can be called opinion. One quick example, you're a racist. That's a pretty damaging thing to say to someone, right? I mean, that's one of the worst things you can be called. In almost every jurisdiction in America, you cannot sue someone for calling you a racist. Courts say, it's opinion, it doesn't really have a firm meaning. Everyone calls everyone a racist these days, so we're gonna say that's not defamatory. So just a real world example.
A more concrete example from just this week, you all might have been following the libel case that was brought against the Washington Post by the boy from Covington High School in Ohio, Kentucky?
Kentucky.
It's a Cincinnati border community. Remember, these are boys who were wearing Make America Great Again hats, who went to a demonstration on Capitol Hill. There was a Native American elder and veteran there. Photos circulated of him seemingly sneering in the face of this Native American elder. The story later came out that that the situation had been much more complicated than that, and that he had walked up in an effort to try to perhaps calm the situation. His version of the story was very different than the Native American elder's version of the story, and very different than the version that immediately had circulated and that the Washington Post had circulated from people on the scene who had sent them photos. And the court there, I guess in Kentucky it must be, just dismissed that libel suit a couple of days ago on a variety of grounds, but the particular example that I'm pointing to is the question of whether the Washington Post, conveying that the tribal elder said, this person stood in front of me to block my passage, right? That was the tribal elder's opinion of what was happening. His opinion of what was happening was that what was stepped in, that the blocking of his passage was what was happening, and the Washington Post conveyed that. The elder said, he blocked my passage, and the court said, we may well take as fact that it wasn't why he did that, but it isn't a defamatory fact to suggest that the elder thought that his passage was being blocked. That's a dynamic in which sometimes we see this scope of opinion coming into play.
When I first started to come to New Hampshire, it was a really deep red state. And I know this was a little bit of a bluish island in that, but things have clearly gone quite a distance here. And I just want to read two questions, and there were none on the other side but to pair with this. But anyway, here goes. What about serial liars like Rush Limbaugh, Sean Hannity, Alex Jones? They know it's false, and yet they publish it, usually without legal consequence. And is the New York Times versus Sullivan case being used by the political right, Fox News, for example, to accelerate the trend toward alternative facts? Are we protecting a right to lie intentionally?
Yes. The short answer is, yes, the actual malice rule protects those people just as it protects all media and indeed non-media speakers about public figures. Specifically in the context, first of all, Alex Jones is actually getting his butt handed to him in a defamation suit right now. So
the answer is no, is what he means.
I think that involves the Newtown shootings, and he claimed that the kids were crisis actors or whatever, just blatantly false statements that he knew were false, and I think he probably is going to be held to account for that. Folks like Rush and Hannity, this is what we were just talking about generally, not just actual malice, but opinion. And again, courts look at context for opinion. And if it's the context of a statement, a show like Hannity, where viewers understand that they're not exactly getting the objective truth, they're getting something other than that, or if it's in the op-ed pages of the newspaper, the courts are going to look at that context and say, we're more likely to find this to be opinion and therefore non-actionable.
That's as it should be. If we have a dynamic in which I'm watching something and there's a view over the top of it that says our view of things or whatever, and I convey something in that dynamic, even if that view is abhorrent to me, I prefer a system in which that view is protected so that when the our view banner is over me, I have the freedom to articulate what my view is. The question was, is it providing space for people to lie intentionally? And of course it isn't. The Sullivan Standard says that if you engage in knowing falsity or reckless disregard for the truth, then you have proven actual malice. And so if you decide to say that children who died in a school shooting are crisis actors, you lied intentionally, and there is liability for that. That our defamation system has space for a successful libel suit in that context.
If and only if you can actually prove by clear and convincing evidence that that person knew they were lying. And the fact that that standard is so difficult to meet means that in many, many, many cases where the people definitely knew they were lying, you're not going to be able to prove it.
That's true. Alex Jones is losing. If that's the concern, right? That was the stated concern.
For both of you, should retweeting and forwarding false defamatory statements be actionable libel?
That's a really good question.
Sure. So just from a black letter law standpoint, the answer is yes, you can be held liable for republishing the defamatory statement of another, but the rub, and very appropriately, is that you have to have the appropriate level of fault. So just retweeting something or just forwarding something is not enough. I have to have acted with fault, meaning negligence, or if it's a public figure, actual malice. If I retweet something believing it to be true or not having any reason to think it's not true, I'm not going to be liable for that.
And notice that that's not new doctrine. That's just old doctrine mapped onto new circumstances, right? Because the same was true 100 years ago if you were a shopkeeper who sold the newspaper, right? And the question was, you passed along these lies to other people, or if you're the reporter who passes on the lie of someone who you had every reason to believe was telling you the truth when you quoted them in the newspaper story, that level of fault is republication prosecution always comes with a brand new, fresh face of trying to figure out whether the new actor met all of the requirements.
Okay. This comes from the stream from Granite State. For what period of time does someone who was formerly considered a limited purpose public figure remain vulnerable or liable in the context of newly developed controversy?
That is a really good question, and there is no specific answer to that question. It's whatever the judge thinks is the short answer to that question.
It's whatever the precedent says, but
There's
yes.
very little precedent on that
That's right.
question.
So it seems clear that if, let's imagine you were a limited purpose public figure for something that happened 10 years ago, and that same controversy resurfaces 10 years later. We start talking about it, it becomes a matter of public concern that we all care about, and it's in the headlines again. Then that's resurrected, and presumably your role in it becomes a matter of an ongoing matter of public concern as to that matter. But there are also plenty of cases that suggest that someone who was a public figure in the past does not remain a public figure for purposes of different controversies, sort of tangential controversies down the line. I agree that we don't have a ton of great doctrine. And one of the reasons we don't have a ton of great doctrine is the reason that Dick pointed out at the beginning, which is that the Supreme Court has essentially left the field on this. They have stopped giving us, there was this wave of cases. I teach this out of this media law case book that's sort of this thick, and 90% of the cases are from 1964 to 1978, and then it's just this golden era of media law and then nothing. And a whole lot has changed about who we are as a nation and who we are as a media since then, and we just don't have great answers. I agree that it would be great if we could get some clarification.
I literally stopped practicing law in this area between 1996 and 2007. And I went back to it in 2007, and there's a big annual conference on this at which RonNell is a speaker, and one of Andy's partners has been a speaker most years. And so I go back to this thing after an 11-year hiatus, and literally nothing had happened.
We hit pause. Just here to remind you, Sullivan still exists.
Right, yeah. Continuing legal education with nothing to educate you about.
Feeling really good about my contributions to that conference now.
This one is just for you, Andy. It says, you are a plaintiff's lawyer in a field in which you claim that plaintiff's cases are impossible to win. Why are you spending your career beating...
Don't show him the handwriting. That wasn't me. I didn't write that.
Why are you spending your career beating your head against a brick wall? Or are you?
They're impossible for most lawyers to win. Look, my firm has won actual malice cases. It's not completely impossible. It is extremely, extremely difficult. For every case we've won, and there haven't been that many of them, there are hundreds and hundreds of cases we don't even take because the standard's so onerous. And I think that is really an important consideration is access to the courts. You're not going to find a lawyer. Most plaintiffs' lawyers work on a contingency fee, right? Or maybe not most, but in a lot of fields where you don't pay unless you win. You don't pay the lawyer's hourly rate because you can't afford it up front. No lawyer is going to take an actual malice case on a contingency unless it's just the most egregious, crystal clear case because that standard is so difficult to meet. So persons of moderate means, they never even get the representation they need. Now, that being said, my firm, we are experts in this area. We have developed expertise in terms of how we can present to the media the prospect of legal risk, even given the actual malice standard. So, it's a fact of life. It is the standard. It's something I have to deal with in my practice. The cases are not absolutely impossible to win, but they are extremely difficult to win, and my day job is a challenging one.
It's against my interest as a law professor and the associate dean of a law school to say so, but the law is not the only remedy in the world. And it is often not the best remedy. And so the Jim Johnsons of the world, right, lots of you at the break wanted to say to me, what will happen to Jim Johnson? What remedy does Jim Johnson have if he's locked out of the courts or if he can't meet this standard? And the answer is that Jim Johnson will try to hire a lawyer, and the lawyer, like Andy, will turn him away. And then he will engage other avenues of remedy. He will engage counterspeech as a remedy. He will go to the newspaper that published his letter to the editor that made him a limited purpose public figure in this case, and he will say to them, here's a story. There's a blogger in our community who is falsely accusing people of being rapists and who is destroying their business, and here's the situation and here's what happened. He will talk to other people who, the same people who are interested in that debate and have conversation about them. I admit it is a flawed system, and I admit that it is super hard to unring a bell after a reputation has been damaged, but it isn't the case that the law and staggering damages of million of dollars of damage is the only tool that we have for remedying our reputations. In fact, there are entire agencies that are sort of the next tier down from Andy's firm that are not doing legal work, but are rather doing reputation remedy work, public relations and outreach, and helping you with your Google searches and other sorts of things that are the mechanism by which people seek to remedy by more contributions to the marketplace of ideas.
So we've got about 15 more minutes, and I want to do 2 more questions so we can take a little bit more time with these if you want. In criminal law, I think you can say, to reduce it to its essence in this country, that the main point is that it's better that a few guilty people go free than an innocent person be jailed. Here, I think one of the central questions, and we've hinted at this, but I'd love both of you to talk about it head on. Is it better to protect a few falsehoods than to punish some truth? Or is it better to protect a few reputations even at the cost of punishing some truth?
Yeah, look, I think that's an interesting question that kind of gets to the heart of what we're talking about, which is trying to strike a balance between 2 competing interests. The way that question is constructed, I'm not certain that I really think it's a zero-sum game. I think that we can strike a balance where people can obtain remedies for falsehoods and the media can go on doing what they're doing. I mean, the media in this country was free and active and existed in 1963, and then Sullivan happens in 1964, and I'm not sure there was a major sea change in the media in 1965. So I'm not sure that the actual malice rule really is that necessary to the media doing what they're doing, and I'm not sure that the media would be immediately put out of business if the actual malice rule was relaxed. In fact, I'm sure and certain that they would not be. Since we have a little more time, one thing I want to talk about today was what's the answer, right? Like, if we're going to get rid of the actual malice rule, what do we replace it with? One of the things I was reading and preparing for this debate was Justice White's dissent in the Dun and Bradstreet case, and I thought he had a really, really interesting idea. He actually voted with the majority in the New York Times case and then came to regret it. And he said, actual malice isn't working, it struck the wrong balance, but one idea that he had was damages caps in defamation suits. So this is a hot thing in the med mal arena right now, where we're placing limits on how much people can recover because we don't want to put doctors out of business. I think that's something that could be considered in the media realm, and maybe it strikes a balance between allowing people to obtain some compensation, some redress, and most importantly, I mean, it's not always about money, right? Most importantly, that jury verdict that affirms that what they said about you was false. With the actual malice rule, you never get there. You never get that, let alone the money. So I think that's an interesting idea. I don't know if it'll ever happen, but maybe that strikes the right balance between the individual's interests and not putting the media out of business.
I just, before you respond, RonNell, I just want to say, as a matter of the history of the press in this country, I think it is simply not correct that the press in 1963 in important ways resembled the press today. There was a revolution in press coverage in this country, and I think almost everybody in journalism would identify it as occurring between about 1967 and 1974. The press's coverage of Vietnam in the later years of Vietnam and Watergate is a fundamental watershed in the history of the press, and we could argue till the cows come home about whether Sullivan had anything to do with it, but it may have.
And thinking in the opposite lens, what would have happened to the press if Sullivan hadn't happened? I think it's probably true that in the run-up to Sullivan, the press was operating in a vigorous, important
trying to cover matters of public concern, doing their best to engage us on politics and social issues. But the point is that the court was faced with a question of whether to allow litigants like Sullivan to bring newspapers like the New York Times to its knees as a result of that kind of exposure. And I think the better question is what would have happened if Sullivan had come out the other way. If Sullivan had not if the court in Sullivan had not found the way that it did, I think it would have been deeply problematic for the coverage of these sorts of important issues in the future. On the wider question of which thing we give up, accept some defamatory falsehood in the name of protecting wider truth, or the converse, the Supreme Court has consistently said, as a matter of First Amendment doctrine, both as an originalist matter, what the founders had in mind for us when they created a First Amendment, and how our doctrine has developed over time, that it is always the case that we protect things that we abhor in order to have space for what we think has to happen in conversations in a democracy. And that's a thread throughout all of First Amendment law. I tell my students at the beginning of my First Amendment course, the motley cast of characters that you're gonna see in a First Amendment casebook, right? Nobody's gonna be fans of any of the people who are bringing these cases, right? It's dissenters and pornographers and pedophiles and people who are wrong and Nazis, right? And the Westboro Baptist Church. Nobody is really applaudable in terms of the folks who are invoking First Amendment rights. Because the truth is, if you're saying something that everyone loves, that everyone finds great, you don't need to invoke the First Amendment. You have a majoritarian rule that will protect you. The Bill of Rights is designed to protect things that we are not totally confident that the majority will protect. And bound up in that is some notion that we have some arguably lamentable wins, where the case comes down and the court makes clear to us in its opinion, we don't think that what happened here was honorable. We're not pleased at the outcome. We agree that there is harm and that there is a victim, but we have a wider structural commitment to something that we have to do. And for sure that is, if we're asking doctrinally what the United States Supreme Court has said about this, the answer is that we have to have some space for defamatory falsehood in order to make sure that truth eventually emerges.
I want to let you respond, Annie. I just want to point out, RonNell mentioned an originalist argument, and a number of you mentioned this to me, and I saw it this morning. There's a quite interesting op-ed in this morning's Wall Street Journal laying out an originalist argument that elaborates on what RonNell was just saying. Yeah.
So I want to make a quick point about New York Times v. Sullivan that I would be remiss if I did not mention during this debate. So we've talked about this as the seminal case, right, that created the actual malice standard, and how the press needed that breathing room, and if they didn't, the New York Times could have been brought to its knees by this huge libel verdict. And one of my arguments today is that the press really doesn't necessarily need that breathing room of the actual malice rule. It already exists in other areas of defamation law, and that is absolutely true of the New York Times v. Sullivan case, where the court decided to create this actual malice rule. That case could have easily been decided against Sullivan and in favor of the New York Times on traditional libel law concepts.
I agree.
And you have to agree with this because the court actually sort of did. The advertisement in question was not of and concerning Sullivan. It didn't mention him. Any court today, I think, looking at that would say that is not of and concerning. You lose on a motion to dismiss. The other one is what we just talked about, republication. So in that case, the New York Times published an advertisement that was written by someone else. I think a court could have easily looked at that and said, there's no fault for the New York Times unless you can show that they acted negligently in publishing someone else's advertisement. If they had no reason to question whether it was true or not, then they probably didn't. So I find it very interesting that the seminal case that created this standard didn't need it.
The only...
Both of those were litigatable issues.
Well, I've got
I could have won that it was of and concerning him.
I've got one last question, but I do want to just press you a little bit on this for a second. This was in Alabama in 1964 about the civil rights movement. I think it is arguable that there was no state court in the state of Alabama that would have ruled in favor of the New York Times, up to and including the Supreme Court of the state of Alabama, and up of and concerning, if it is not a constitutional matter, that case would not have been reviewable. So if the government of Alabama is in the hands entirely of racists, as honestly, I think any candid history of Alabama in 1964 has to acknowledge that it was. George Wallace was the governor of Alabama in 1964. That may not be entirely true.
That may be like a policy argument for the Sullivan case in 1964. I'm not sure it's relevant today when we're having this debate. But also, I mean, obviously, I can't disagree with the state of play in Alabama at that time. But as a general rule, courts don't go out of their way to make rulings that are unnecessary to decide a case. And my point is that that case could have been decided even by the U.S. Supreme Court on traditional libel law grounds without creating an actual malice standard.
Okay, here's the last audience question for both of you. Is the current, more conservative Supreme Court likely to agree to hear a libel case that allows them to narrow free press rights? Are there such cases currently in the lower courts?
This is a super interesting question. And part of the underlying premise of the question is that we've now been conditioned as a people, I think in recent years more conditioned as a people, to think about the court's conservative bloc and liberal bloc because there are at least some cases in which our instincts about their ideological preferences or at least the ideological preferences of their appointing president, send us signals about where we think they're going to go on various issues. The First Amendment is a very, very floopy area in this regard. It is, and it's been a very, very interesting shift in terms of the courts. Did Justice Breyer leave?
Let's assume so.
Identify yourself if you're...
No. Let's give him a break and assume he has.
So the case law that I'm talking about, that I teach my students, these sort of major media law cases that happened in the 1960s and 1970s, the folks on the court who were sort of on the vanguard of First Amendment protection, both of free speech and of free press, were absolutely sort of liberal progressive branch of the court, right? They were protecting dissenters and protesters and artists who were offensive, right? There was this sort of liberal overlay. People in the field sometimes talk about how the First Amendment belonged to liberals in that period, right? It was an era in which it mapped onto that ideology with some frequency. Today, the Roberts Court has a First Amendment view. In the last term, there was actually some allegations from some dissenting justices that the First Amendment has been weaponized for conservative mechanisms, right, as a sort of libertarian, sort of deregulatory tool. If everything that we engage in is expressive and all of the things that we do in our business are expressive, then perhaps the First Amendment prohibits a wide variety of regulations of things like unions and various behaviors by companies, and the First Amendment has become very attractive to the court's conservative wing. And what it means mostly is that there's at the moment we're at this spot where at least some First Amendment arguments are attracting people from both sides of the aisle. I'm not totally certain that that's going to remain true. There were a number of opportunities for the court to take some very divisive and really important media-specific cases, press freedom cases. You might have remembered in the early 2000s, there were a series of cases involving reporters' privilege, where Judy Miller from the New York Times, for example, was jailed after refusing to give up the name of her source. It ultimately proved that it was Scooter Libby, who was the Cheney's chief of staff. But she didn't ever say who that person was. It was only when Libby himself came forward and announced that he was the source that she was I think she was jailed for something like 80 days or something. There were a series of those cases where they went all the way to the Supreme Court, and the Supreme Court refused certiorari. It has control over its own docket, and so it refused to grant cert. There have been a number of other times where people have gone knocking and the court hasn't answered, but increasingly what's happening is that nobody's going knocking, and that's because they don't have a perfect lay of the land. They do not know exactly what this court, although a very sort of pro-free speech court, it's not at all clear where it would fall on some of these wider concerns. And certainly Justice Thomas, which is sort of to bring us around to where we started, has tipped his hand. He has made clear that he thinks that the entirety of the Sullivan structure should be scrapped and that we should remove all of the constitutional overlay to libel law, not seeing these actions, these speech tort actions, as having anything to do with the First Amendment at all. If I were advising a media company, I would be very skittish about suggesting that we push for those sorts of answers until I had a better sense of what this court thought and what this court might do.
Andy?
Yeah, well, I agree with most of that. I mean, first of all, I defer to the constitutional law scholar on the specifics of where individual members of the court might stand on these things, but I agree that even the conservatives on the current court seem to be pretty protective of First Amendment rights. Despite Justice Thomas's recent concurrence in his view, and people should seek that out if you're interested after this, Google Justice Thomas's concurrence in the McKee v. Cosby case. It's a really interesting rundown of the history of libel law in America and his view of the actual malice standard. But I don't see a lot of momentum to ditch the actual malice standard. I don't think that's going to happen anytime soon. But changes can be made at the margins, and I think it would be a good thing for everyone involved if the court started taking some of these cases and at least adding some gloss and detail onto some of these standards that maybe have been expanded a little bit or a lot of it too far by some of the lower courts.
Yeah, I think it's notable that Justice Thomas circulated this, actually concurrence, I guess, right? And
Right, it was a concurrence because he voted to dismiss, he voted not to take the case.
right, and no one joined him. And he still published it. I think this has been a terrific debate. Thank you all for being here. Thank you for coming.
Thank
and
you.
thanks to our debaters.
Thank you for coming, and we'll see you next week. Individual privacy, face recognition, and all the rest. Thanks.